See what's going on. Good evening, everyone. Thank you so much for joining us on this lovely Wednesday evening, so early in the school year, or is it early in the school year? I'm not sure. My name is Christine Lai. I'm delighted to welcome you all this evening. We are having some technical issues on my end. So, you know, the screen that I normally share at the start of the presentation, I'm just going to read through, and everyone's going to have to use their imagination. Welcome to Special Education Legal Fund's first webinar of the year. This is Special Education Advocates and Attorneys. What's the difference? We are pleased to have our distinguished panelists, who I will introduce in a moment, joining us for tonight's discussion, and we're so excited to have everyone. Before we begin, Special Education Legal Fund is deeply thankful for the support of our corporate parent education program partners: Winston Preparatory School, American School for the Deaf, Chapel Haven Schliefer Center, Fusion Academy, the Pinnacle School, Spire School, Villa Maria School, and the Hubbard Day School. We are deeply thankful for everyone who supports this program in support of getting information to parents about special education and special education legal matters. So before we begin, for those of you who are not familiar with us, I wanted to share a few words about Special Education Legal Fund. Special Education Legal Fund's mission is to provide resources and knowledge to families in need with children in the special education system. S.E.L.F seeks to empower parents and guardians to full advocacy for their students and to help level the playing field for families in need with children in the special education system. We were founded in 2018 to provide grants for families in need with children in the special education system. And since our founding, we have provided over $430,000 in grants for legal support, from qualified special education attorneys to 100 families in 40 school districts across Connecticut and Westchester County. Now, just a little bit of housekeeping before we begin. The Legal Assistance Program is our flagship program, which provides grants of up to $5,000 to families in need for a special education attorney. This program will commence accepting grant applications for the 2021-2022 school year next Monday, September 27th of 2021. Please visit our website, which I will put in the chat momentarily when I'm kind of done, with this bit, which is www.spedlegalfund.org. And under the programs tab, you will find the instructions on how to apply for the program. As of this year, we are no longer accepting inquiries for this program via email. All of the applicants to the program need to go to the website to start the pre-screening process. This year, we have another change, which is that the deadline each month, we review grant applications on a monthly basis. The applications with their documentation will be due on the 15th of each month, and phone interviews must be completed by the week following, which is the 22nd. All applicants will be notified of their status by the end of the month. All of this stuff is on the website, so please don't feel like you have to, hurry to write it down. Eligibility for the program is the same. Families are eligible for this program, for the legal assistance program, if they have adjusted gross income of below 300% of the federal minimum poverty line, which is $76,400 for a family of 4 in Connecticut. Your child has to have a current IEP, and you must reside in Connecticut or Westchester County. My next little plug for S.E.L.F is going to be about the Advocacy Support Program, which was new this past spring. And we're very excited this month to be opening up the Advocacy Support Program to the entire state of Connecticut. The Advocacy Support Program provides up to $1,000 in special education advocacy support to students in need who have a 504 plan or an IEP plan in Connecticut only. The grant recipients must select an advocate that is on our Advocacy Support Program list. Only the advocates on this list are eligible to receive grants from this program on behalf of this program. So Julie Swanson, Diane Wilcutts, also members of this list and are eligible to receive grants through this program. Again, you also have to go to the website to www.spedlegalfund.org, and you will see there are instructions on how to apply for this program there as well. So now that the niceties are done, I'd like to introduce our panel participants this afternoon or this evening. First up is Jennifer Laviano, who is an attorney in private practice in Connecticut in the field of disability and civil rights law. Jen graduated from Skidmore College and earned her JD from Quinnipiac University School of Law. She joined the family business, as it were, and began practicing, really kind of at your dad's feet, right? Or not feet, but you know what I mean. Jen is also a published author. Her and Julie's tome on special education for parents is usually right on my desk, but for some reason I can't put my hands on it right now. And she and Julie also have a podcast, which is super fun. And I can't wait to be invited to be on it to talk about what I'm not sure, but sounds like a great time and a really amazing resource for parents. What's the name of the podcast again?
The Special Ed Files, and you're booked.
All right. That, from your mouth, there we go. Okay, next up is Julie Swanson. So Julie is the parent of a young adult with autism spectrum disorder, which, she will share with us later, has sort of driven her life's mission, which is as a special education advocate, an author on special education issues, and also in her newest incarnation as life skills lady, which is phenomenal. Julie's been practicing as a special education advocate for ages and ages and ages, and is incredibly well-versed in all aspects of the law and representing parents in the state of Connecticut. And last, but certainly not least, Diane Wilcutts. Diane is an advocate who for over 20 years has provided just amazing and amazingly skilled advocacy services on behalf of Connecticut children with disabilities. And, the list of qualifications that Diane has is really, really too long to mention. She teaches for, you do, training for COPA, you've taught for rights law, for the Autism Spectrum and Resource Center. I think that, if I'm correct, Diane, you have a real, you have a real sort of expertise and soft spot for language-based learning disabilities, and so you're a real expert in that area, which is tremendous. So I'm going to let you guys talk a little bit more about your backgrounds and what brought you to special education a little bit later. But next is, and last, is my disclaimer. No webinar would be complete without it. So this webinar panel is presented for informational purposes only. It is intended as a resource for families who are navigating the special education system in Connecticut or New York, and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys or advocates on this panel. So for webinar participants, this panel should be viewed as a public forum. Please do not ask questions via the Zoom platform, either in the Q&A or the chat, about your child's legal or educational situation. Please email questions to me at Christine@spedlegalfund.org. I will put my email in the chat. And in your question, please refrain from any comments that include identifiable information about your child, including name, grade, school, or school district. Please remember that your screen name may be visible to participants in the panel, as well as the panelists and Special Education Legal Fund. Finally, this webinar is being recorded and may be distributed or shown at a later date at the discretion of Special Education Legal Fund. So there we have it. Special education attorneys and advocates, what's the difference? Thank you all so much for joining me this evening, joining us. I would love if you could all, talk a little bit for 1 or 2 minutes about, what kind of brought you to the field of special education law and special education advocacy, because I think that's a really important thing to understand, for parents to understand where, everyone's coming from. So Jen, do you want to go first?
Sure. So as you mentioned, special education law is sort of a family business. My late father was a civil rights lawyer and plaintiff's lawyer in a number of areas, mostly employment law, but also other, civil rights. And in like the mid to late 80s, he had a client who he was representing in an age discrimination case whose son got into trouble at school, and they were having a meeting, an emergency meeting, because the district wanted to expel this student. And he called my dad and said, they said I could bring a lawyer. Will you come? And at that time, there were very few people doing this in Connecticut. And he went and he looked up the statute and, went and was sort of blown away by how all that he had read the night before about what they were supposed to do, they weren't doing. And he also was already suing that school district on a First Amendment matter. So he knew their lawyer and all of that. So I'm one of 4 girls, and I'm the only one he could sucker into going to law school. So I've been sort of
Here you are.
him. Yeah, here I am. So I mentored under him for many years. He passed away, unfortunately, about 20 years ago. But so this is now 25 years of me doing special education law. So that's how I got into it. I knew very soon into practicing that this was the only field I wanted to do, that I did not want to do general civil rights, that this was really where I wanted to direct all of my energy.
Or God forbid, corporate law or something.
Oh,
like
God. Real estate. Yeah.
Wonderful. Thank you so much, Jen. Julie, would you like to go next?
Sure. Well, so my son, who is now 27 years old, was diagnosed with autism back in what I refer to as the dinosaur days. It might as well have been 1 in a zillion. And soon thereafter, we all know what happened. The numbers and the incidence of autism sort of went through the roof. I eventually became eligible for special education in the school district. We realized that the program they were offering was not appropriate. We asked for an ABA program, a program using the principles of applied behavior analysis, and everyone said, "What's ABA?" And right after they said, "What's autism?" By the way. Let's just say I hired Jen's father to represent me. And I was the second due process case in the entire state of Connecticut to get ABA services. We thankfully prevailed. This is how I met Jen. So not only, are we colleagues, but we've become friends over all these years, and we've known each other ever since, and partnered with each other in many things. And so I learned from her father and from Jen, and from just when you go through a due process, it's like being thrown into special education legal boot camp. And I was very involved. And after I finally, was prevailed and got my son the appropriate education that we thought he required, people started calling me. And I said to myself, geez, I either go back to do what I used to do, which was a television producer, or I think I might do this. This is like, I felt a calling. And I never turned back, and I've been doing it ever since.
Wonderful. What a great story. And so great that you guys are, connected and, have that sort of, your own kind of little Sped family. Diane, would you like to go next?
Sure. I like Julie, and like many people in our field, have children with disabilities. I have a daughter with high functioning autism. I have a son with dyslexia. And it was one of those things where you sort of learn the hard way. I spent a lot of time wondering why people didn't respond to requests until I started putting things in writing. And then all of a sudden it's like, oh, okay, so that's one thing. And then there was, we have this neuropsych eval, and somehow none of what was in there was ending up in the program. And what's wrong with me? Am I losing my mind? And I started going to these seminars and conferences just to try to figure things out for my own child. And as I was going along, someone said to me, "Oh, I just assumed you were an advocate. You should do that." And I said, "Okay." And I thought it was one of those things where it's like, okay, I'll take one case and I'll see how it goes, and then I'll go from there. And I've never had to advertise. I mean, it's one of those things, there are so few of us, I think, in our field. It's a real word of mouth kind of scenario. And, you know, and I say my school district trained me. All the what to write down versus what's a phone call. And yeah, so it's been very helpful. As difficult as it was very helpful. And just going from there, I got involved with the Council of Parent Attorneys and Advocates, and that's a wonderful resource for parents, for attorneys and advocates, just in terms of training and just networking and camaraderie. But yeah, I never looked back. It's been, you know, 20 years, and it has been so much fun. It's fun for me as the advocate. It is not fun for me as the parent. As the parent, I felt sick to my stomach going to meetings. But with other children, I view it as a puzzle. It's like, okay, how are we going to get from point A to point B? We're going to figure it out. We have no choice. We got to figure it out. And so it's definitely fun. And as far as you mentioned, my soft spot for dyslexia and language-based learning disabilities, absolutely 100%. I feel really strongly that every single child has to learn how to read. It's access to everything. And so that's been, I work with a wide range of disabilities, but that's been a real area of specialty.
And Diane and I started it at the same time, right, Diane?
Around the same time. Yep.
There's more of us now. There were only a handful of us back in the day.
Exactly.
Yeah.
I mean, I think, you know, what you bring up is an interesting point, you know, which I would love to elaborate on, you know, in this and every forum that I speak at, which is that, you know, when I started, you know, S.E.L.F, you know, 3 years ago, I sort of assumed that most of the kids that I saw would have autism, you know, because I'm, you know, an autism mom, and, you know, to hammer everything looks like a nail, right? So I kind of assumed that was going to be what I saw. And I do see lots and lots of students and children, you know, and teenagers with autism. But what I was really shocked about was the number of kids that I see who can't read and are 11, 12, 13, 14, you know. It really was shocking to me that you know, a child could be in the special education system for, you know, 6, 7, 8, 9 years and still not have the appropriate services to be able to learn how to read. You know, that kind of brings me to, you know, what you guys do, which is, you know, I think that a great advocate is a phenomenal resource. I did not have one when I was going through this myself. I didn't know they existed. And so I spent kind of Diane knows the story. Like, I spent kind of 6, 7 months, you know, flailing around and being really, really pissed off. And then finally getting to the point where, like, I hired an attorney, you know, because we kind of went right to that point. But I do believe, looking back on it, that if I had had an advocate, I would have, maybe my son would have been able to stay in the public elementary school longer. He still would have probably been outplaced. We still would have gone to an attorney, but you know, maybe, you know, it just would have looked different. So, you know, what I'd like to kind of kick off this conversation with is, you know, what do you guys see as the difference between an attorney and an advocate? I know that many of my clients come to me and they say, I need an advocate. And what they mean is, I need someone on my side, and they don't actually know what they need. So I'd love it if you guys could talk about, you know, what you perceive as the difference, what you do versus what, you know, the other person does, and sort of vice versa. Who wants to go first? Jen, I'm going to pick on you.
Jen, you should go first, since you sort of lay the foundation for us.
Yeah. So, and let me say, pro con to both approaches, but my goal is almost always that a parent should hopefully be able to get what they want without having to hire me.
Mhm.
And so I spend a lot of time on the phone with parents, at the end of which I say, you're not ready for me yet. You don't need me yet. You don't even know what you were looking for sometimes, and or
Right.
how to articulate it or how the system works. And I refer them to a Diane or a Julie or some of our other advocates. That's my goal, because nobody wants to bring a lawyer into their child's school. That's not, that's not fun for anybody. And so
Yeah.
that's my hope. And most of the time, Julie and Diane and other really skilled, experienced advocates are able to accomplish what their student needs without having to refer out to an attorney. And I know that's their goal too. There are some fundamental differences, and there are pros and cons to both. The number one obviously is that attorneys are licensed to practice law in the state. And advocates generally are not. We do have some advocates who have a training and background in the law, but aren't holding themselves out as a lawyer in that process, which is different. Okay. But for the most part, most professional advocates are not attorneys. They're not trained in the law. That said, simply having a law degree and being licensed to practice in the state doesn't necessarily mean you know anything about special education law. And I would take almost all of our advocates any day of the week over inheriting a file from an attorney who doesn't know what they're doing, because it's it's like, not only did the parent have a mistake made, but it was made with counsel, and that's very, very hard. So so that's really the primary difference. Also, depending on your jurisdiction, and in Connecticut it's changed on and off over the years in terms of the policy. Advocates can handle mediation and PPT meetings, IEP meetings, but they cannot represent a parent in a hearing. There were times in the past where that's been up to the discretion of the hearing officer, but advocates can advise, but not represent the parent. So that means they're not making arguments, they're not cross-examining witnesses, things of that nature. And certainly advocates cannot appear in court. And, and most of the time when we're in court, it's in federal court. So that's the key difference. There are much more important factual differences in terms of the tone it sets with your district, and then some practical things. Like, as an attorney, I cannot ethically, under our rules of ethics as lawyers, it's unethical for me to pick up the phone and call a special ed director if I know that that district is represented by counsel, which virtually every school district in Connecticut is. It would be unethical for me to do that because I can't contact a represented party.
It would be like them calling your client.
Right, exactly. And so it'll be like their lawyer calling my client.
Their lawyer calling your client, right? Exactly.
And so I can't do that. And believe me, there are many times where I really feel like if I could just talk to that director and have a face-to-face or now camera-to-camera conversation, I could convince them to do the right thing, but I have to.
But you can't, you got to go. Yeah.
That's one practical difference. I don't know if Diane and Julie want to jump in, but there's a lot of difference in pros and cons. And there are some circumstances where I say to parents, your stakes are so high right now that I would skip. I mean, if your child's up for an expulsion,
you have to have an attorney.
A criminal matter.
Exactly.
If your school district's bringing a lawyer to the meeting, and you don't even have an advocate, that's a big red flag. So there are some circumstances where I say, we're now in a different ballpark.
Right. Just a point of clarification. Are there states in which advocates do represent clients in due process? That's what I thought. Like New York, maybe.
I think in New York, I think Texas.
Indiana. So there are some excellent advocates out there who've done many, many due process hearings in their states. In many of them, there's states where there aren't many attorneys.
Exactly.
But yes, so that's jurisdictional. There's nothing in the IDA that says that you can or cannot be represented by an advocate in a due process hearing, but most states will have policies or practices about it.
Great. I say to parents as an advocate that my goal is to resolve your matter without you having to go to an attorney. That is my ultimate goal. I'm sure it's Diane's as well. However, if there are forces that be, and there often are, that for some reason, in spite of my best efforts, you're going to end up in a dispute with your district that is going to lead to a due process hearing, then I have to refer the parent to an attorney. But I'm going to button up that case. So when I do hand it over to a Jen or one of our other many capable attorneys in the state, it's buttoned up. They're not going back and recreating anything. It's going to be a very nice package where they,
it's all ready to go. Yeah.
Right. It's going to be ready to go.
Yeah. Like when I get a case from one of you guys, I'm like, oh, this is good. Like, we're just, we're ready to go. Let's just have it, it's all tied up. It's got the bow on it. It's perfect,
Right.
So I appreciate that. And, and it's nice. I mean, I know that you all are, it's hard, just like Jen said, and I say this to, to our clients, and my friends and, whoever else, it's like, once you have brought that attorney into the equation, you have changed the relationship that you have with your school district forever. Yep. And you might be like at the start of that, like your child might be 5, and you're having to deal with them for another 13 years or whatever. So it's something that, I mean, you should do it if you need to do it, but like, it cannot be taken back. And, and an advocate can very often, and Diane, maybe you could speak to this a little bit, and, and Julie, an advocate can very, very often get, all of that stuff done without, that extra element of,
contention.
Boom. Yes, contention.
Yeah.
Right.
Yeah.
And I would be careful too, though, because sometimes I don't necessarily view the involvement of attorney as meaning you're going to war. I think there have been situations, and it's funny, it seems like it comes from the school board attorneys sometimes, where they just want to fight.
Yeah.
And I look at bringing in the attorney at that point as kind of ripping the Band-Aid off and saying, okay, we've got this disagreement, we're moving to the next stage, we've got to go to a hearing, no big deal, we're going to resolve this. So sometimes I look at it as, if we're in that situation, there's absolutely no damage as long as we're professional, as long as we're not making personal attacks and being sarcastic and all of that. It's, as long as we're professional, we're good. Some families actually worry even that having an advocate there can be adversarial. And I just wanted to say, I find it to be the opposite for the most part. It's like, I can help calm things down sometimes where, the parents kind of invested. I also find that some school districts are just more responsive when there's an advocate there. I wish it weren't the case that they have to, they feel like they have to be on their toes because the advocate's there, but in fact, that's sometimes the way it is. The nice thing about PPTs with advocates versus attorneys is we don't have to deal with all the attorney schedules.
Yeah.
It's like if the
that's always really hard. Yeah. And then you have a PPT meeting pushed out like 3 weeks because no one can get on everybody's on each other's calendars. That's so hard. I mean, Jen, I know you know that well. And
the thing with the when you have a board attorney and you have a parent attorney, it's a different kind of conversation. The other thing I like, and it's funny because, attorneys obviously have to have a law degree and they have to have passed the bar and there are ethical standards. With advocates, it's like the Wild West. You don't know what you're going to get. There's no certification, there's no license. We do need a lot of training to be effective. However, there's nobody telling us what that training has to look like.
Absolutely.
And I know a lot of advocates have their own ethical standards, but we're not required to follow any.
Right.
And so, so like, for example, I won't talk to school staff without consent of the parent. If the school staff reach out to me, I say I have to get consent from the parent, but some people will just talk. Yeah. So it's, but in some ways I like not having any restrictions because I can call up. If my client says, can you talk to the special ed director? I can call up the special ed director and talk directly and not have to deal with the attorney on the other side, who there's some who are great. Some board attorneys are very reasonable. There's some who are impossible. And the last thing I want is to just waste my time trying to negotiate with them. Whereas if I talk to the director, sometimes we can get things done. And the other thing is that advocates are able to be we're kind of required to be pretty creative in terms of the, just the problem solving, the troubleshooting, and we get to be, part of the child's team. So Yeah. But at the same time, I understand. I mean, my goal is to make it so parents can advocate for their child without necessarily having me involved. There are some families who I see them once a year. You know, they say, oh, can you just come to the annual, and the program's good. I just want to make sure all the boxes are checked. And there are some that, you know, things get in place and then they're good. So that's, you know, that's the objective.
I mean, I think the goal obviously is for, you know, the parent to be able to advocate for themselves independently, obviously, because, you know, nobody can afford to have, you know, a lawyer or an advocate even like with them, you know, for, you know, a 15-year, you know, sort of journey necessarily.
Although it does happen.
I'm sure it does. I absolutely know. I'm sure. No, I'm sure. You brought up an interesting point, Diane, which, you know, I'd love if all of you can kind of expand on, is the idea of qualifications. And actually, you, Jen, brought it up too in a slightly different way. But, you know, special education advocates aren't required to have, you know, sort of a broad-based certification, which makes it difficult for parents to, you know, kind of filter through everything. You know, I know that, you know, myself, you know, through S.E.L.F, that, you know, I struggled for a really long time, you know, to be able to add advocates to, you know, the programs that we were offering, even though I do deeply believe in the work and the effectiveness of what y'all do, but there wasn't a way for me really like pointing to this particular qualification to say, okay,
hard to vet us.
Right. Like to say like, okay, you can choose any advocate that you want that is in this, like that has this qualification. Whereas we could do that with attorneys. You know, we could say, you know, your attorney must be, you know, this, that, and the other thing, you know, must have practiced special education law for 7 years, must have that as a majority of their practice, must be, you know, so it was a different kind of thing. So maybe if you guys can talk. And so Jen, you also, gosh, I'm packing a lot into this question. You had also mentioned that you've had referrals for clients who've had attorneys that were not special education lawyers. And how is that, you know, how does that impact the case? Why is that a problem? Why should you never hire an attorney that's not a special education attorney to do special education work? So who wants to go first? That was fun.
Yeah, there's a lot. Let me start by saying this, you know, I'm licensed to practice virtually every kind of law except patent law, but I wouldn't take a workers' comp case. I don't do it. I don't. So I'm licensed to do it. I wouldn't. I don't ethically or as a professional feel that I would take that on. People make mistakes. You know, my brother-in-law is a lawyer. So, you know, I asked him if he would come with me to the IEP meeting, and he came with me. He said, do me a favor. People are human, and, you know, it is what it is, but sometimes this is a very complicated statute.
It is.
And it changes all the time. We get a new decision, and suddenly what we thought we could rely on for many years, now a whole new conversation, depending on where you live. And there is a reason you have to go through training and pass a bar in order to be an attorney. So, you know, what I would say is that parents, when they get to the next level, whether that's a mediation or a due process hearing, heaven forbid, if they are trying to explain away things that they made as mistakes because they didn't understand what they were entitled to, and they didn't ask for certain things, or they asked for things they weren't entitled to, it's very understandable to a reasonable hearing officer or judge that a parent's not a lawyer, and even if they are a lawyer, that they don't do this kind of law, that, you know, they made mistakes. When you add to it that they had an attorney there, it takes that plausible deniability away from the parent of being able to say, I was just doing my best and I didn't know, because they were represented by counsel, which is why I say, this is not a field to dabble in, you know. Now we all have to regulate our professions if we want to feel like my profession, we're required to regulate one another, but my viewpoint is that all professions should care about the quality of their profession and the integrity. That means sometimes we have to train other people who are new to the field. And believe me, there have been times I've gotten phone calls or I've seen questions on various listservs I'm on by a new attorney where I go, you know, oh gosh, that really worries me that you're out doing this already. That's a really basic question, but we have to train. I'm co-chair of the attorneys committee for COPA because We believe in training.
Yeah.
That said, as with evaluators, as with service providers, parents of children with disabilities have to be cautious consumers and talk to other parents and do the research and find out whether they're getting somebody who's as skilled and experienced as Julie and Diane, or someone who is brand new to this field and maybe doesn't know anything about autism because their child had dyslexia. And so you need to make sure you do your due diligence.
Absolutely.
I would add to that, I always like to quote my mother on lots of things. And she used to say, you're the only person who can make your reputation, right? And for someone like Diane and me, who were not regulated in any way, shape, or form, it is our reputations. It's the years and years and years of people, thankfully, saying nice things about us because we're effective. Now, I'm sure there's a few out there who would say something opposite, because I've been doing it for 20 years, who knows? But the point being, it's that word of mouth on how we get most of our referrals. That is because we have been doing it so long, and we're competent at what we do, that we're effective. And then that in and of itself is our calling card, if you will,
Right.
Aside from being able to have, we're a member of the
X, Y, and
Board
Z,
Attorneys
whatever,
Association.
Right.
Yeah. So I think it's just really your reputation has to precede you in when you're an advocate.
Yeah.
Right.
Would you agree, Diane?
Yeah, I definitely do. And I find it helpful to just, I know Julie does the same thing I do, which is to constantly do professional development in legal areas, in instruction and assessment, so that we're current. And so so there's a lot of training that goes along with the experience. So it's not just experience. I did just want to comment on the beware the attorney who doesn't have a lot of experience practicing special ed law. I've read hearing decisions where the family was massacred because the attorney that was hired clearly didn't understand special education law. I mean, it was clear from the decision. It's a very specialized area, and it's really easy. It takes years. I mean, even as an advocate, I say, it took me years to really have a sense of what was going on. I've got mediation agreements from attorneys who clearly knew nothing about special education law, and the family was happy. Oh, we got this independent evaluation through our agreement. Yes, and they waived claims for what was potentially years of compensatory services where they could have maybe gotten a private placement or something. So just beware, if people are looking for special ed attorneys, obviously Jen is excellent. We have a lot of really excellent experienced special ed attorneys in Connecticut. You can check with the Council of Parent Attorneys and Advocates. Again, they have a list, and I'm sure S.E.L.F. also has a list of people that, not that they recommend, but that they can provide as a resource for people to interview. But yeah, absolutely.
Another good way is, I think, through chats, Facebook groups and things like that. I mean, I think parents are also a really good resource to say, do you have any, because the names get out there, I see that happening a lot as well.
No, that's true. But it's important also to understand that, your experience with one attorney might be totally different than someone else's experience with the same attorney, which for sure, we have 100, clients now, over the past 3 years. And some people have had amazing experiences with particular attorneys, and others have not, because, a lot of the time it's like, it's this very complicated cocktail. And this is the case with, advocates too, of personality and skill and, the rapport and the communication, sometimes, let's be honest, you come to the table, maybe you don't tell the advocate or the attorney the entire situation that's been going on. And then they find out later. And then there's all these complicated things
Sure.
that happen, but it really is, I always say, I'm really this, it's not a requirement. I don't mandate it, but I really love people to meet more than one person, if at all possible. I know that sometimes resources and time and whatever else don't allow you to do that, but it really is so important to meet more than one person because, ain't nobody gonna, marry the first person they date, except for my mom, but that's another story. It's you have to see more than one person, and
it's style, it's background. It's also, parents will call me from certain districts and I'll say, look, I'm happy to have your case, but I want to be really clear about something. Your special ed director hates me with a
right. Exactly. There's different, exactly. There's that relationship is there. Yeah,
right, exactly. And likewise, hey, I have a really good relationship with this district and their attorney. And I have, and sometimes, as Diane alluded to, sometimes school districts and their lawyers are happy when parents bring in an advocate or an attorney, because sometimes the parent doesn't understand the process or that what they're looking for is slightly different from what they're saying, or they're understandably very emotional because they've been gaslit or, just obfuscated left and right about what they're looking for years. So all of that is true. Now, I will say something that is also different about being an attorney in this field versus an advocate. When a parent calls me, I have to feel that they have a case. A legal case, that there's some violation of the law or something that they are entitled to. That's
such an important thing, Jen, not to interrupt you, but it's sometimes bad things happen and they're not illegal.
I tell people that almost every day. It's
that's bad. I get it. That's really bad, but nobody broke the law, unfortunately.
Right. Nobody broke the law here. And of course, whether something is appropriate for a child is a very subjective thing. And I, usually say to a parent, you always have the argument that you don't think it's appropriate as a parent and you know your child best, right? But when it comes down to it, Julie and Diane and many, many good advocates are serving a role of being the voice of the parent in the meeting, regardless of whether they're going to pursue some legal claim. This process is really complicated, even for people who've been doing it for years, understanding the paperwork, all those things you can do without ever taking it to the level of having a legal dispute. But if a parent contacts me and I don't feel like there's been any major violation, and I don't feel like we have the basis for asking for something different, I'm going to say, I don't really think you have a case. And it's my obligation to say that. So that's also a difference.
That is a big
difference. That's the job. It's the job is to have an assessment of the facts in the case and render an opinion as to whether or not, it can move forward. Advocates are a little different, because, you guys sit in in sort of a role where you can be more of, you can do, what lawyers do in, many cases, but you also can be, a guide, a mentor, someone that helps a parent go from, ground zero of not knowing anything at all, to level 10, hey, I got this. I mean, not that lawyers can't do that too, but it would just be prohibitively expensive and probably not, the best use of resources.
Right. I say to parents that I want you to not have to work with me anymore. But like Diane alluded to, if a problem comes up in 5 years, you might have to call me up and say, I need you at a PPT, Julie. So I do a lot of it, as I'm sure Diane does, teaching, and I'm sure you do too as well, Jen, but explaining things to the parents, because I want them to know what I know. I want them to leave our experience and say, oh my gosh, I know so much more than I used to, and nobody's going to pull the wool over my eyes. And that's really my ultimate goal. Not to say that all school districts are nefarious in trying to pull the wool over parents' eyes, but it happens very easily. It's that old adage, what you don't know can hurt you, and you sort of have to know as much as the other person. And naturally, if you don't, you're going to miss a lot of important stuff.
Because they're never going to tell you what you're missing.
Oh no,
you're never going to tell you what you're missing.
Heard that off the record thing that happens with teachers, providers who pull parents aside and say, just so you know, you
Yeah.
didn't hear it from me. But,
Yeah. Yeah.
but, you know, I also think one of the things that when I talk to Julie and Diane and other colleagues of ours who are advocates, there's a lot about I can't even imagine how much whipping these two people take on a daily basis, because when I go to a PPT meeting,
Oh,
the
gosh.
board layer is
Yeah.
there, which is one of the downsides, is that the board layer will be there, and that means that they're going to be not committing, you know, the egregious errors that they might if the
Right.
board lawyer wasn't there. But I'm at least given the deference by, they don't like me sometimes, but I'm given the deference that they assume I know the law, right?
Right.
Julie and Diane, who know the law so well and have been doing this for so long, will sometimes walk into a district, especially if it's one that they've not dealt with before, and they get tremendous pushback by the team and accusations of like, the parent isn't asking for this, you're asking for it. It's like, well, they hired
no.
me. That's why I'm asking for it.
Yeah.
They take a lot of flack. They take a lot of flack.
You know,
it's I don't take it seriously.
Well, you know, but sometimes it does set a tone, right?
Mhm.
And they want to, and I'm not saying all, but sort of diminish our role or try to make it all about us. I'll tell you a story. You know, when I was first starting out and you know, I didn't have a reputation yet, right? And I used to tell Jen the stories about how people were really, I had some really terrible things said to me, and I wasn't respected. And I used to have a lot of the directors say to me, so tell me why you're qualified to be an advocate, right?
Oh my God.
And I, you know, I'm like,
Yeah.
to the point
Which
where
is just not a thing that anyone should ever say to anyone about anything.
No,
but
and
whatever, you know.
me today would have reacted very differently, but this was the me about 18 years ago, you know, and I went back to school to become a disability specialist. This is after having a master's degree. I went back to school to Manchester Community College and went through their disability disability specialist program, because I, just for the sole purpose of, when people asked me, well, what qualifies you? Because there's no qualifications to be an advocate, say, well, I'm also a disability specialist. Didn't do me a whole lot of good, by the way, but I'll never regret going through that program, because I absolutely loved it and fell in love with so many things that I learned. But I think sometimes, not so much anymore, but especially when I was newer, people would try to test me or diminish me, or, you know, what makes you so qualified to do this? I don't get that so much anymore.
I just say I'm not qualified. The parents asking about, the parents requesting additional speech and language services. So enough about me.
Yeah,
exactly.
No,
I'm not qualified at all.
No, I'm not. I'm totally not qualified.
I have no qualifications.
I don't even know why I'm here. Like, you know, I took a
the
wrong
thing
turn.
is,
Get them in the parking lot. Yeah.
Exactly.
when those things are said, it's somebody in that meeting trying to set a tone.
Of course.
And my job at that point is to undo that tone.
Yeah.
And get it back to an even playing field. And I will tell you this, one of the reasons that I love virtual PPTs, and let's talk about that. I love them because parents and school districts are on an even playing field.
Yes.
We're not sitting around their big table with them looking at each other. And, you know,
they weren't there in the meeting room before you got there, you know.
Well, they still have.
They were, but, you know, you don't see it.
But exactly. And I have a client or somebody was telling me about how a client heard the meeting before the meeting, and they were talking about the parent. That recently happened. But anyway, my point being, I think it is a really nice forum for parents because of the even playing field that it puts everyone on. I personally love it. I don't know. How about you guys?
I love it too, not just because it's a lot. So when parents, you know, go to the trouble and the expense of hiring one of us, we want to give them as much value as we can without having. And
not the dreaded travel time. Not the dreaded travel time. Exactly.
And also for districts too, because, you know, frequently evaluators or other professionals, either the parents or the district, have not invited them because they can't and don't want to pay for the travel time.
Yeah,
now
for sure.
pop on to a call for 10 minutes and not charge an arm and a leg for that.
Yeah,
So
and charge 15 minutes a time. And that is a huge,
exactly.
the game
there's
changer.
a lot of ways in which it's
And
been
parents
much
don't have to take the day off of work.
Yes.
Right.
Yeah.
They can say, I need to go into the conference room for an hour. What's that, Jen?
I'm saying, as with anything else, there's something lost sometimes. I can't
Yes.
read in the room the dynamics between staff in the same
Yeah.
way.
Mhm.
Just as I'm communicating with my client by text during the meeting, they are probably
They're doing the same thing. Yep. Mhm.
I mean, there are downsides to everything in life, but in general, yeah, I think they're way better. And mediations too. I've told the state I have no intention to ever go back to.
Exactly.
When my client and I are captive at the Board of Education for an entire day.
Yeah, as they're like going back and forth between the
Yeah.
like whatever.
Yeah.
It's like there's nothing worse than that.
It's awful.
Yeah.
It's really bad. I have a question from the audience actually.
Oh,
You know, if your child has an IEP, at what point would you expect a parent might need an advocate for a PPT meeting? It's a pretty broad question, but I know I sort of feel like I know where this parent is coming from. You know, and I'm going to throw in my 2 cents, which is like when you feel like something's not right, you know, kind of trust your instinct on how you feel. Like if you feel like something's not right, then maybe it's time to look at like what is going on with the team in your program. But the 2 of you probably have a way better answer than that.
No, I think that's an excellent answer. And I would say if you're asking, I mean, chances are if you're saying, is it time for an advocate? Usually it's a good idea to call one and just talk and maybe, you know, bounce ideas off of them and find out. I will say that most families I talk to have said, I wish I called you earlier.
yeah.
And the thing is that there's no investment. You don't have to hire me. You can call and just ask for my opinion about something. There are some people who call and I can just say, oh, you want to talk to that person, or, you know, this, you need to draft this email, you know, whatever. And that's that. So sometimes it's really simple. I would say if people are asking for something that either they suspect the district is not going to agree to, or if they are hearing from staff that they're going to make changes to the program that they're concerned about, or maybe they're telling them no. You know, if the family's asked for something like evaluation and the principal called them up and said, we're not going to do it. Right. You know, and it doesn't count if the principal calls you up and says they're not going to do it. Advocates can be helpful in terms of just making sure that you use the right words. I mean, a lot of it is just knowing what words to say and what to put in writing and that kind of thing. And that can move things along more efficiently. So yeah, so if in doubt, call. I mean, and I'll tell parents that when they call and say, do I need an attorney? And I'll say, if you're wondering if you need an attorney, it's a good idea to talk to an attorney. And, you know, if they're saying, well, I am looking to get my child evaluated. And I said, well, just generally always can talk to an attorney, but that's also something I can help with, you know? So on the other hand, if they're saying, my child's been arrested and we're looking at expulsion, and it's like, okay, just here are the phone numbers. You know, do you want me to dial for you? So it's just, yeah.
Or, you know, there are certain things like if you're having a manifestation determination meeting, that is if your child has been disciplined in some way. And for those of you who don't know what that is, you know, we can't discriminate against people in this country, right? So if you're disciplined, you can't discipline children with disabilities in the same way if in fact their disability, their behavior was a manifestation of their disability, thus the manifestation determination. I can't begin to tell you how many times parents have gone into manifestation determinations, not knowing what it is, thinking it was no big deal. And it's determined that the team says, oh no, this had nothing to do with the disability. And the kid gets expelled. So there are some procedural things that might pop up that you want to say to yourself, I better work with someone, whether it's an attorney or an advocate, because the stakes can be pretty high. In addition to what Diane said, I mean, I do have some parents who call me and say, I don't know if I need an advocate. And I'll say, you know what, why don't you just get me involved to do a file review. You
Mhm.
tell me everything, you know, I get a lot of information from them. Let me go through and see what I see. And then
Mhm.
I'll have a phone conversation and say, here's what I gleaned.
Mhm.
Are these things that you think you knew about? And some
Right.
parents don't even know
Right.
that there was something they should have known.
It's like an audit, you know?
Yes.
Well, and I would say one time you might want to be talking to an advocate or an attorney is if at the meeting or before the meeting, as Diane says, sometimes, you know, in advance, somebody whispers in your ear or something,
Yeah.
they want to make a major change to the program, and including graduation if you don't think your child is ready to graduate. And the reason is that is a very strong procedural protection under the statute called stay put. And
Mhm.
that is in Connecticut, it's federal that stay
Mhm.
put exists, but in Connecticut, in order to exert your right to stay put, you have to take action as a parent. You can't
Mhm.
just sit back and say, oh, they changed my child's placement,
Yeah.
and 6 months later I see it was a big mistake after they've
Yeah.
already implemented it. You've lost your opportunity to exert your right to stop them changing the placement.
Mhm.
And so that's one area where I think it's a good idea to be on the phone, is if they want to change your
Yeah.
child's placement, they want to
Yeah.
graduate your child and you don't think that they're ready.
Yeah.
And again, discipline is a big one
Yeah.
because it could applies there in some circumstances.
We
And-
though that is actually one of the very few you know, when I get an application that is for a manifestation, I actually, those actually don't go through the normal review process for us, because normally, you know, as you know, the manifestation hearing is in like, 7 days or whatever.
Yeah.
And they can't wait for the period of time that,
Yeah.
that we would go through our process. So I generally will approve those, assuming that we have funding right away. We have had a handful of those over the course of, of the past 3 years. And they're always something that, you absolutely need an attorney like right away, because the defense is the disability, and
Right.
and that is just what it is. Yeah, so I, thank you for bringing that up. That's a great point. And it's really, it's really terrible to go into that situation and not have the appropriate support.
Right.
Right.
And another time that I always tell parents to bring an advocate to the meeting is when we have the results of an independent evaluation. What I realized, some of my families were making this common mistake, and what they would do is we would get the independent evaluation and the family would say, oh, great, I'm golden. This person's going to make recommendations.
Right.
The school will have to listen.
Right.
And
Yeah.
so they
Right.
wouldn't bring me, they would bring the report.
Right.
Right.
And then I would talk to them 2 years later and they said, oh, well, the school just wouldn't do it.
Yeah.
And I'm like, oh,
Yeah.
it's like, let me help you with that.
Yeah. Yeah.
So,
yeah.
so sometimes they think that it's so obvious and
Yeah.
the district will listen. But if there's an independent evaluation that includes recommendations that the district previously has not been willing to do, it's a good idea to make sure you have an advocate with you to follow the process and to make sure, because it is, a lot of it is about, did you use the right words?
Yeah.
Mhm.
Did you say, I am requesting
Yeah.
this? Are you saying yes or no to my request?
Yeah.
And if it's no, can you please put that on prior written notice and explain to me what's the
Explain to me
basis
why
of the
you're saying
refusal?
no. Yeah.
So it's just so it's not just a matter of them, and sometimes people don't realize
Yeah.
that school didn't actually say no. They had
Mhm.
this big long conversation going around in circles with you over why something's not needed,
But they never
said the
actually
word no.
declined it. Yeah.
And
Mhm.
that's
Right.
that's where an advocate can come in
Yeah.
Right.
and help clarify
I
that.
see that a lot of times. Like that's a great point about the IEE, is that like it's like, you're like, I got the IEE, this is great, but sometimes, the stuff that's in the IEE doesn't make it over the finish line, doesn't get,
Right.
doesn't get, implemented. And then, 6 months later, a year later, it's like, well, this is what the evaluator said, but the school didn't agree and they didn't do any of it. And now here we are.
And we could have done something about it.
Right.
That's what makes me crazy. So that was probably what was happening like the first 3 years of my practice.
Mhm.
I would hear from people later about this and it's like, oh, but now we just make sure that we're there. And the great thing is that, schools in fact are allowed to not implement everything
Yeah,
in the eval.
that's right.
The evaluator makes recommendations. The PPT, which includes the parents, considers whether or not to include those recommendations.
Yeah.
But if they say no, it's not the final no. A no at the PPT is not the final no. And so sometimes districts start off with no just to see if the parents will go away.
Right.
And sometimes they are told, not that they're, predetermination, sometimes they're told to say no at the PPT,
Mhm.
and with the idea that it's going to resolve in another forum, usually mediation or something like that.
Right.
So it's one of those things where if you have an advocate or an attorney guiding you, you can go to the next step.
Yeah.
And it might not even be that much effort.
It might, because how many times are those no's by the building level chair of the meetings who has been trained that you don't agree to things unless you get it cleared from central office, and one called to central office by a good advocate, and yes, we'll do it, so it doesn't have to be an arduous piece of litigation.
That's one of the things that's always gotten under my skin a little bit, is I might have a case and I've done everything in my human power to get the team to yes, right?
Mm-hmm.
And all it is the attorney comes along and within 5 minutes, it's a yes. And you're just like, come on now.
It's those letters, it's those little letters.
Right. So, districts will see how far a parent will go, and sometimes that's why attorneys have to get involved, because they'll they just don't want to resolve it at our level.
But even with an advocate, sometimes they'll resolve it. Sometimes we work things out after the PPT or even before the PPT, because we'll do our own little predetermination meeting with the special ed director. And sometimes it's a matter of just doing it in writing. So following up the meeting and just documenting in writing what was said. Because if it's not in writing, it never happened. Mm-hmm. And so sometimes we go to these PPTs and the district doesn't write down exactly what we requested or whatever. And as soon as we put it in writing, the answer changes. Sometimes, advocates can work with families in mediation. I always say, consider having an attorney for those, because you do have a legal document there. Yeah. But there are lots of, there are lots of opportunities to resolve things. Very few cases actually go to a full-blown hearing.
Yeah, that's true.
So 95% of the time when someone files for a hearing, it resolves without the actual hearing.
Yeah.
So
but like 95% of the time, if it goes to hearing and you represent yourself, you're going to lose. So
you lose. It is. It's
actually it's probably higher than 95. Actually, it's probably
96% of the time.
Yeah. The other thing you need to know about Diane, she's a master researcher and statistician.
I have a question. She knows her numbers. I love numbers, girls. I have a question from a participant. I think we've talked kind of, broadly about this, through, and this is a thread that's gone through all of our discussion tonight, but this individual is wondering if you, the panelists, could provide a list of circumstances when someone needs an attorney as opposed to an advocate. I'll go first. Reviewing a legal document. How's that? That's mine.
100%. And that's, serious disciplinary issues, especially anything that could lead to an expulsion. Anything where your child might be exposed to some criminal issue, because believe me, expulsion pales in comparison to incarceration. Okay. And you could go into an IEP meeting, like a manifestation determination, as Julie was describing before, and make an admission on behalf of your child that they did something that they have a Fifth Amendment right not to admit having done. Yeah. And now you're in a whole other ballpark, and it's in fact, when I get involved in a situation where there's a criminal matter, I refer them to a different attorney, and I handle the special ed piece because the stakes are so high. Yeah. If your school district is bringing in an attorney to the meetings and you don't even have an advocate, there are some good advocates that the school will send their lawyer once they find out they're involved, because they know that the parent is in very skilled hands. But if you don't even have an advocate and they're bringing in an attorney, there's a big red flag there, and you're out of your league, frankly, even if you have tremendous background and training in various fields.
Yeah. And is that like, Jen, would you, sorry to interrupt, but would you say that's the case, like, you know, if they're bringing the town attorney as opposed to someone from Shipman and Goodwin, like any attorney at all?
So there's only a handful of towns that use a town attorney as their special education attorney, like their corporate counsel. There are some cities and some towns that do that. Okay. But it's not the majority of the state in Connecticut. So, you know, I would say any attorney, frankly, because it could be somebody who actually is skilled in special education. And and if it goes to the next level, they'll be representing the family.
Yeah.
If the school district has filed for a due process hearing because they've denied your request for an independent evaluation, because now you have a hearing officer who's assigned to the case and the stakes are much, much, much higher. I would say, you know, those are the big ones. Certainly, if you absolutely disagree with a change they're about to make in the program and you need to assert that stay put right that I was talking about, you'll have to file for a hearing to assert it. You can't just say, as I say to parents, it's not like Beetlejuice. You don't just say it 3 times and something happens. You know, you actually have to file for a hearing to exercise your stay put rights. So those are the kinds of things. And then certainly if things have gotten just so off track and you feel completely overwhelmed, as if you cannot possibly articulate your child's needs without a huge fight. And I've had those cases, and good advocates usually can extricate the tone, you know, but sometimes it's well past that point. Sometimes they're referring you to DCF and they're, it's
all right. That's the other.
That's a good one.
Situations where I'd say, you might want to at least talk to us. As Diane said, you don't have to hire a lawyer to talk to one, you know, consultation.
You know, another one, Jen, might be that sometimes there are overlapping legal issues that fold in, like Title IX issues, discrimination, sexual harassment, you know, that sometimes start overlapping what we're getting involved in.
You personal injury, if your child's been injured.
Right.
I mean, I will tell you, I have
restraint and seclusion, you know, those kinds of things.
Right. I work with a lot of you know, parents who have students who are questioning or transgender, and there are, you know, they've been denied access into the bathroom. You know, all of these type of issues can then start overlapping. And while it doesn't mean that Diane and I can't handle something like that, because you don't have to be an attorney to be aware of those issues, but also just start thinking, wow, is this getting like pretty complicated that now we've got multiple layers of legal issues? I just wanted to throw that one in there.
Diane, you have anything to add?
Oh, no, I was just thinking the DCF situations always refer to an attorney, and you want an attorney who knows both navigating DCF and special education issues. And personal injury attorneys, that comes up periodically. But if a personal injury attorney is involved, you want to make sure they're coordinating with the special ed attorney. If they're not the same person, usually they're not, because one can impact the other in a negative way potentially. So,
and those actually come up a lot, you know, like in cases where, you know, there was some, you know, obviously there was bullying and that resulted in, you know, injury to the child, then, you know, then that is, you know, obviously, you know, a matter that, you know, kind of is is a little bit beyond, you know, what the special education attorney would normally, you know, would be normally in the purview. But that is like super, super helpful. So I have a person that is asking about prior written notice and whether prior written notice, I'll just read the question. How about that? Some parents have experienced school districts saying the final IEP serves as prior written notice. And is this legal and or accurate?
The final IEP serves as...
Well, page 3 of the IEP is prior written notice. But yeah, that is telling us that this is all the explanation we have to give you. This IEP is not true.
So interestingly enough, every state has different paperwork, right? And some states have a prior written notice that is separate from the IEP, which is what I believe is going to start happening in 2022 here in Connecticut, because I was on the committee to form the new IEP. And I'm almost positive that's the direction we're going to start taking. It's not going to be embedded in the
document.
IEP paperwork anymore.
And also on that point, and I hate to, I sound so much like a lawyer sometimes, and it annoys even me, but depending on what state you're in, also there are what we call consent states and non-consent states, meaning in some states, if you don't sign the IEP, not sign that you attended, you don't sign off on the IEP, the school district cannot implement it. Connecticut is not one of those states. Connecticut, they give you the notice. You usually get a little form letter with the IEP saying, here's the IEP. We planned at the PPT of X and such date. We are going to implement it on this date. And if you disagree, you actually have to file for a hearing and invoke your state put rights. In some states, you actually need your consent to implement
to implement it. So you have to physically sign it. And some states have like line item, approval, don't they? Like where you can approve like pieces of your IEP and not the whole thing as a whole.
I would argue that federal law allows a parent the right to select which things. I've had this fight with board attorneys, both in hearings and in mediations, where board attorneys will say you take it or you leave it. This is we proposed it as a comprehensive interdisciplinary evaluation, and I'm saying we all agree that this child needs speech. You cannot condition their consent.
Everything else on that. Yes,
exactly.
Yeah.
Right.
Interesting. Right. I mean, it would seem, I think that Massachusetts is one of those states. It would seem that allowing that type of flexibility would make for, a more harmonious, sort of, team environment.
In fact, my argument since the 2004 reauthorization of the statute is that since Congress put into that version of the law that after a parent files for a hearing, the school district is required to hold a resolution session, to me, that shows congressional intent that you are supposed to be able to resolve some of your disagreements, even if you can't resolve all of your disagreements. So I would argue that every state, that's the law, but I'm sure if a board attorney was on this panel, they would tell me I was wrong, but I'm used to that.
I had a question in the chat, which is, and I think, Jen, I think that you kind of answered this already, but what percentage of Connecticut school districts would you say have the town attorney representing them during mediation? I can only think of one, and I don't think that district will be doing it much longer.
If the parent has counsel, almost all of them. If the parent has an advocate, sometimes it's just the director. But as I say, and when parents ask me this, please know that while that director may be attending this mediation without counsel, their counsel is a phone call away. They have counsel on retainer in the district in most circumstances. And so you're going to be dealing with somebody who has an attorney analyzing that document, and you are not. And you have to remember that and make your decisions accordingly.
Yeah. This is a little bit, this person is asking what special education advocates generally charge. And I'm asking it, I'm asking it because honestly, like, a lot of my clients, they don't ask for the help because they just assume that they can't afford it. So I do think that, demystifying the process a little bit is helpful, and also know that there are a multitude of services available in the state for families that are of sort of a low income or sliding scale services that are available through advocacy organizations that can help parents as well, like Favor and Sped Connecticut, things like that.
Diane, what do you think the range is these days?
It's pretty wide. I know some advocates are around like 75, 80, and I know one who charges over 300. So everyone, it's a really wide range. I think it often goes with the level of experience, but not necessarily.
Right.
I mean, where you're located,
it depends on where you're located as well.
Right.
Right.
And the
But-
same is true with attorneys. It's a wide range as well, based on a lot of factors.
Mhm.
And some attorneys have different models of how they are retainer structured than others. And, you know,
Right.
ask around.
Yeah.
Ask
But,
Yeah.
you know, the
Or
other thing
call-
too is clearly, I will make a blanket statement that it's less expensive to hire an advocate than an attorney.
Yes, that's
I'm
absolutely.
gonna, I may
correct,
be
yeah.
wrong with some
Generally,
people
I
on that,
think-
but generally speaking,
Generally speaking.
and I think that depending on the advocate you choose and is you can get a pretty good bang for your buck
Mhm.
when you go with an advocate who is able to do the full breadth of what you might need and be able
Right.
to resolve it at their level.
Right, absolutely.
So,
I also think it's important for parents to understand that it is fully within your purview to ask an attorney or an advocate or whoever that you are thinking of hiring how many hours they think your case
Absolutely.
would take to resolve, with the obvious caveats of things that we can't
Absolutely.
control, like, you know, like
Right.
the
Which is
district
everything, but
particularly
yeah.
intransigent or
But I have
whatever.
I have that conversation all the time. And you know
Yeah.
what I like to say to parents, because look, I'm a parent who had to hire my own
Right.
attorney. And I know financially what it cost me to go to
Yeah.
due process.
Yeah,
And had I not prevailed at the time, we were a lot younger and just, you know, starting out, I probably could have lost my house looking back at it all
Yeah.
these years. Okay.
Yeah.
The stakes were high. But for me, and again, you know, this is just me, I feel it is the ultimate investment in your child.
Mhm.
Because as my mother used to say, and here I go again, there's no one in line waiting behind you to advocate for your child. So if not you, who? So it really is it's an investment that can change the trajectory of your child's life. It really
Absolutely.
can change the outcome.
Absolutely.
And I know that's saying a lot, and I don't mean that to puff up our shoulders, but it's a matter of taking the course that maybe a school district thinks they should go down because something might be more financially prudent or for whatever reasons, and turning that track to go, no, we're going to go this way. And so the stakes are high. It's often a big stakes reward.
Absolutely.
Right.
Absolutely.
And people can get, you know, different levels of support. As Julie was saying, you know, someone might just want a file review and a consultation to figure out what's the next step, you know,
Mhm.
what are the next steps for me? And then other people, you know, want an advocate at every single meeting. So it just depends.
Right.
Mhm.
And there are organizations like Sped Connecticut where they'll offer advocacy services on a sliding scale.
Yep.
Or favor, I
Yep.
believe also. So there are different
yeah.
organizations. So it's something that should be accessible, but I'm so grateful to S.E.L.F.
Yes.
for making this accessible, to making advocacy services and attorney services accessible to so many people who absolutely would never be able to afford anybody. So
Thank you.
we'll see what happens.
Absolutely. Well, this has been tremendous. I would like to thank you all for joining us, all of our, you know, our panelists and our participants. Thank you all for joining us this evening. It's been great. And this will be available on, you know, on our Facebook page, on our own website, you know, on YouTube, on Vimeo, on all of the basic channels, just as soon as I can get it up. So hopefully later this week. But thank you all for joining us. We appreciate all of you so much, and for everything that you do on behalf of families and children in special education in the state of Connecticut. Thank you, Julie. Thank you, Diane. And thank you, Jen, for joining us this evening.
And Christine, thank you. And for S.E.L.F.
Thank you. Good night, everyone.
Good night.
Good night.